Good morning and welcome to, when I say the chambers, I literally mean the chambers, as in the Medford-Jackson County Chamber, the Grants Pass Chamber, and the Klamath Falls Chamber, all joining together with BBSI to bring you the Employment Law Series. This is about the 6th year that we have been presenting this series. And just a couple of housekeeping items. Some of you don't know, but I'm broadcasting live from the UAE, sitting in downtown Dubai this morning. And I just joked in the warm-up session, we're about 13 days ahead of you. So I want to take care of a couple of tips here this morning. You're going to want to take Secret Ambition to Show in the 5th. And you're going to want to take USC by 3.5 points in the next game. So that's a nod to Joe there and the USC Trojan fans in the audience. Sorry about the Beavs and the Ducks, but what a great run. This has been a great run too. The 6 years that we've been presenting this is the largest crowd that we've had in some time. So we really appreciate you being here. In a few minutes, I'm going to turn it over to Heather and Josie and Joe. But I just wanted to say really quickly, you know, labor or employment law, of course, is to everybody's benefit, the employer and the employee. But sometimes our friends in the legislature run amok when they are creating those employment laws and they become burdensome. Then you throw the addition of, well, right now, a legislative session and excuse me, a global pandemic and all the rules and regulations, guidelines around COVID into the mix, and it becomes very, very confusing. It's a daunting task to try to stay up with everything. And so our good friend Sean Ray, who Joe will introduce much more formally in a few minutes, is going to do a great job of helping you understand how to navigate these, I guess what I would call whitewater times. So as I mentioned, I'm going to turn it over to my friends and colleagues here. We have Heather Tramp, the executive director from the Klamath County Chamber, and Josie Malloy, the president and CEO of the Grants Pass Josephine County Chamber, and Joe Rossi, the area manager from BBSI. So I think if I remember the order of all this correctly, I'm going to go to Heather first. I'm sorry I don't have some exotic background behind me like the Burj Khalifa or something like that, but it was the best I could do on short notice. I'm going to be over here for a few more days wrapping up the peace talks, and then we'll be back in Medford shortly. So with that, thank you all for taking the time to be here. Joe, thank you, and BBSI for your sponsorship. And of course, Sean, thank you for being here as well. Heather, take it away.
Thank you. My name is Heather Tramp. I'm the Executive Director of the Klamath County Chamber of Commerce, and I want to thank all of you for joining us today for, like Brad said, our 6th annual Employment Law Series. I know you all have a lot of questions in these times. A lot has changed. There's a lot coming down from legislature this year if they get anything done up in Salem. So we're watching that closely. But I know you have a lot of questions, so I'm not going to take up much of your time. We'll let you get on to Sean Ray in a few minutes. But mostly I want to thank BBSI for continuing to bring this valuable resource to all of our chambers. And I want to thank Brad and Josie from the Medford-Jackson Chamber and the Grants Pass Chamber for partnering with us. It's great to be able to collaborate in this way and bring a resource like Sean Ray to all of you to answer your questions. Thank you.
Hi everyone, I'm Josie Malloy. I'm the President and CEO for the Grants Pass Chamber, and I'll echo the same words that everyone else said. We're excited to be a part of this. It's cool to collaborate with the other chambers, and a big thank you to BBSI. This is always such great beneficial information, so please ask questions. We know you have lots of them. This has been a hard time for our businesses, but a great opportunity to ask those hard questions. And thank you for joining us. And I'll turn it over to Joe.
Good morning, everybody. Joe Rossi here with BBSI, and thanks again for participating in this year's Employment Law Series. It's always great to be partnering with our chambers in Southern Oregon, with Brad and Josie and Heather, and what they do so much for small and medium-sized businesses, all businesses actually in Southern Oregon. We bring this to the entire business community to help you through, what has been probably the most tumultuous year we've ever faced in 2020, and now what's coming upon us in 2021. As I mentioned, this is BBSI's 6th year in bringing this really important law seminar to you. I think we all agree 2020 was the most stressful year in business ever. It wasn't just the wildfires and the election stress and everything else, of course, the pandemic. But now, as Brad mentioned, we're facing a legislature that's imposing a ton of new employment rules and protocols and regulations on small business. So we know how important it is that you're here to listen to Sean today and what he's going to present. We're also, I would want to mention that, BBSI truly rose to the occasion last year in helping more than 100 of our 200 business partners secure over $13 million in PPP loan funding and restore over 1,000 employees to the workforce last year. In this year's ELS, it's more important than ever to provide businesses with the understanding of, the employment laws that are going to affect you and your business. With that, I'll tell you at the very end, BBSI will make ourselves available after the seminar to apply, to ask questions to us, and just feel free to give us a call, and our HR managers will be standing by to help out. One of the things I'm also going to do today is just talk a little bit about what it looks like to do this Zoom webinar. As most of you have attended a Zoom webinar, you're used to a feature like this, but for those of you who haven't, I'd like to take the time to explain that the Q&A part of this program. As you've noticed, you're not on screen, and you won't have video or microphone capabilities. You're just simply going to be an attendee. And the chat function has been turned off for this presentation, but you'll be able to ask questions to Sean throughout the program using the Q&A feature located at the bottom of your screen. At the end of Sean's presentation, I'll be going through your questions and moderating them to get them to Sean. So feel free to type in your questions as they come up, but know that we won't be getting around to actually addressing your questions until the very end of the presentation. So again, that Q&A feature will be open during the entire duration of the program. Just want to encourage you to put those in. I am monitoring them, and I will get to them as best as I can. We're going to allow about 30, maybe a few more minutes than that, 30 minutes after his presentation's over, to get to those Q&As before we actually, end this webinar today. As most of you know, Sean Ray has been, and he is a managing partner and attorney with Barron Liebman LLP. He's been doing this now for 6 years. We're so indebted to Sean. He's actually become a local celebrity. He knows a lot of people, and a lot of you know him through these webinars. He's been representing management and employment matters for quite a while with Barron Liebman. He defends employers against discrimination complaints, sexual harassment lawsuits, retaliation claims, wage and hour claims. He represents employers in the state and district court, as well as with BOLI and the Washington State Human Rights Commission. So in addition to litigation, you guys probably know that Sean also works with employers to ensure compliance around changes in the law, including drafting and revising employee handbooks, providing customized trainings. He has done a lot with Southern Oregon businesses to provide that kind of counsel. So I'm going to let this go to Sean. Let's get going on the webinar. Sean, thank you so much for being here, and let's kick it off to you. Thanks so much.
Thanks, Joe, and thanks, everyone. Glad to be here. What a year we've had here. The last 365 days or so have been pretty crazy. As many of you know, I was down there a little over 365 days ago, doing the employment law series last year, early March. And, I was down there in Grants Pass and in Medford. And we initially planned for sort of an update seminar, kind of like what we're doing here a little bit. But, about a month before it came time to fly down there for that seminar, some things changed. And we basically turned it into a COVID-19 seminar based on everything that was unfolding. And, I'd been on the media circuit for a while. I was on OPB radio. I was on Coin TV, kind of talking about the employment law implications of COVID-19 way back when, before the lockdown had happened. And so we sort of parlayed that into a speech down there, and everything, you know, I told everybody down there, you know, it was great and it was all good, and it lasted about a week, and then the regulations changed and the laws changed, and there was new rules put in place to amend the laws temporarily, because it was just such a fast moving and changing environment here with this pandemic. And so now here we are a year later, and, you know, unfortunately, we're still talking about it, still talking about the impacts it has on the employment landscape. But now we're sort of in an optimistic role looking forward, you know, instead of looking at how we lay people off effectively and conserve our scarce labor resources, you know, due to government mandated business closures. Here we are looking at how we can safely start bringing people back into the workplace. And so I'll share my screen with you all so you can see the nice slideshow we've got here put together. Here we go. So here's the topics we'll be talking about today. First and foremost, we'll talk about some of the workplace considerations due to COVID-19. And, you know, some of those have changed a lot since this all started, but there are some tail end COVID-19 things that we need to consider. Vaccines are now out there, they're available. So what do we do with that? Can you mandate vaccine policy in the workplace? Can you require all of your employees to get a vaccine? Should you require all your employees to get a vaccine? Is that a good idea? What about remote work issues, right? We've got people that have been working from home for about a year now in some instances. How do we bring them back into the workplace? Do we bring them back into the workplace? Do they just transition to a remote permanent work position? Do we have some sort of a hybrid, half the work week in the office, half the week remote? You know, these are all considerations that employers need to think about, as well as all of the policy considerations that we need to have in place around those types of issues. So we'll talk about some of those, and then some accommodation questions as well that kind of dovetail with the vaccine and or other issues with COVID-19 and reintegrating employees into the workplace. We'll talk about some critical handbook updates that you want to make sure you have in your employment handbook. First and foremost is the Oregon Workplace Fairness Act, which is a pretty imposing law that drastically changed the landscape for employers, at least as far as litigation goes, with harassment, discrimination, retaliation type claims. So we'll talk about the impact that's had, came out last year, and what it requires you to do going forward, because there is a required policy that you need to have in your handbook for that. And then we'll talk, I guess we'll end it on a little bit of a downer. We'll talk about sort of the administrative rules, legislation, potential changes. It was mentioned in the intro about the sort of the attitude, in Salem toward employers, and the drive to create even more employee-friendly legislation than we already have here in Oregon. So that's sort of the framework for what we'll be going over today. As Joe mentioned, if you have any questions, go ahead. We'll try to get to those at the end. I'll leave at least a half an hour of time at the end of this thing to answer as many questions as possible. Of course, if we don't get to your question or you didn't get it fully answered, my contact information will be there on the very last slide. So feel free to reach out to me with your questions as well following today's seminar. So first and foremost, let's start with all things COVID-19. It's taken up a whole year of our lives, so let's keep talking about it anyways. The EEOC does say that you can mandate vaccinations in the workplace. There's a nice, handy website they have. I've got it right here on the screen for you. You can just go to the EEOC's What You Should Know pages. What they have and what they started doing, essentially they always have these guidance documents, and they had sort of this ADA Rehabilitation Act overlay of how these two laws and other equal employment opportunity laws overlap and interact with each other. And what they did was they updated that at the start of the pandemic to include how those statutes are changed or how they interact with COVID-19 and the CDC's recommendations and other government laws, allowing or requiring things to happen during the pandemic. And so that has been updated throughout the course of this pandemic. It's a great resource. So if you have a question, that's a good jumping off point to figure out whether or not, you have to do something or not do something. But they also lately incorporated a section on vaccinations. And what they said there is essentially that yes, within reason, with exceptions, you can require all employees to be vaccinated before they come into the workplace. Now, keep in mind, the EEOC cannot necessarily express an opinion outside of its own jurisdiction. It only enforces federal law. It cannot tell you what's allowable under state law at all. And so keep that in mind, take it with a grain of salt. But that is, in a nutshell, the answer to the question, can I mandate my employees get vaccine, is yes, but because there are these exceptions. So what exceptions are we talking about? What concerns do we have? First and foremost, the vaccine itself is not a medical examination. The EEOC makes that clear. You're not being examined. You're simply getting a needle stuck in your arm and you're being injected with a vaccine. It's not considered a medical examination, so it doesn't trigger any of those protections under the ADA. It's just not going to be considered a medical examination. Similarly, asking an employee for proof of vaccination is not a disability-related inquiry. Remember that disability-related inquiries are regulated by the ADA, and they're very restricted on what we can ask. So you simply asking an employee whether they've been vaccinated or to show proof that they've been vaccinated is not considered a disability-related inquiry, and you won't run afoul of the ADA for asking for that. Now, the questions you ask in a pre-screening could be medical inquiries. So if you were to run your own clinic on the workplace, you have to be very careful about that, because any questions you might ask in pre-screening could be medical inquiries, because perhaps you're asking about pre-existing conditions to know whether there's going to be some type of adverse reaction to the vaccine. If you were asking if they've had a history of anaphylaxis, to weigh whether or not they're at risk of going into anaphylactic shock after receiving the vaccine, that would be a medical inquiry. And so you want to be careful about that type of ask and that type of behavior. Employees also have a couple of roads to decline to get a vaccine should you mandate one for everybody. First and foremost is disability-related reason for declining the vaccine. If you have a disabled employee and they decline the vaccine due to their disability, they are entitled to an accommodation under both the ADA as well as Oregon's state law preventing or prohibiting employment discrimination. So if you have a mandatory vaccination policy in your workplace, you cannot discriminate against somebody who chooses not to get it or declines to get it due to a valid disability. And so you have to engage in that interactive process to see whether there's an accommodation that can be granted to that employee. Perhaps it's allowing them to work from home. It might be that they're required to wear a mask in the workplace, even when we get to a point where masks are no longer required. Once the vaccine is very widespread, the CDC and OSHA and all of those other entities may relax their requirements for workplaces to where we no longer have to wear masks. In that instance, you may still require or provide a mask for a disabled employee who was unable to get the vaccine and requested an accommodation. Also, employees who have sincerely held religious beliefs that prevent them from getting the vaccine are also entitled to accommodation. So keep that in mind. There are valid reasons employees can decline to get vaccinations, and you have to accommodate those requests under the law. Another fascinating thing that doesn't really make sense to a lot of people is this nice statute we have here in Oregon, ORS 433.316. It essentially says you cannot require vaccination as a condition of employment for employees of a healthcare facility unless it's required by some other law. So you can't require doctors, nurses, and medical personnel, the very ones that are going to be treating these types of diseases, to get a vaccine unless it's required by some other law. There currently is no law that requires vaccination. So if Oregon was to pass a law that required medical personnel or everybody over the age of some certain age, except for valid opt-outs due to disability, religion, etc., then it would potentially override this law. Similarly, if there was some sort of federal mandate that hospital workers had to have the COVID-19 vaccine in order to provide treatment to patients who have COVID-19 or have COVID-19 symptoms, then it would similarly override this law as well, and you could require. But as it sits right now, if you are a medical healthcare facility, you cannot require vaccination as a condition of employment because it's not required by some other law, either federally or at the state level. So a little counterintuitive there, but that's out there. So be mindful of that if you are a employer who operates a healthcare facility or otherwise works in the medical field. Another issue here, another concern we have is are unvaccinated employees a safety risk, right? If you want everybody in your workplace to be vaccinated and 90% of them are vaccinated, are those other 10% a safety risk because they are not vaccinated? This is admittedly an old case, way before COVID, 1987. It dealt with the Rehabilitation Act. And in this instance, the individual had tuberculosis, a very highly contagious disease. And they found that that person could be considered a handicapped individual. And the fact that they also may be contagious with tuberculosis does not remove them from Section 504 of the Rehabilitation Act, from the protections afforded there, or allow discrimination based on that impairment, based on that tuberculosis diagnosis. So what you have to do is conduct an individualized inquiry using reasonable medical judgment, and you also have to comply with public health laws in order to assess whether or not you can deem somebody a safety risk in order to exclude them from the workplace without violating the Rehabilitation Act or the Americans with Disabilities Act or any other law that may protect that employee, particularly if they're being excluded from the workplace in a fashion that's detrimental to them. If oftentimes somebody who's not allowed to come into the office will face more difficult roads to promotion and those types of things. And those are, even though they don't get terminated, those can support an adverse employment action. Those are considered an adverse employment action, so they can support a claim for retaliation or discrimination. And so ultimately, you want to do an individualized inquiry. It's the same kind of thing we would generally recommend across the board with these types of things, is we always do individualized inquiry. If you're doing criminal background checks, we always say do an individualized inquiry. Every situation's different. Don't have these blanket policies that just say, if you don't have the shot, you can't come into the office, because there's always going to be instances where you might have to soften that stance. You might have to allow somebody to come into the office that is not vaccinated if you do have some type of mandatory vaccination policy on the books at the workplace. And so be mindful of that aspect of it too, in that you can't just say, well, you're a safety risk, or you're a safety risk to the other unvaccinated employees you might be working next to, because you all may end up getting it. And that in and of itself is not going to be a valid policy that can legally exclude these people from the workplace. And you'll probably be subject to some type of claim, whether it's a bully claim or an actual administrative claim or a civil lawsuit. if you have mandatory vaccinations and an employee refuses, what grounds what are there for you to take action in that instance? We do have a pending lawsuit here in the District of New Mexico, federal lawsuit. And it's a complaint for injunctive and declaratory relief. So it's not a claim for damages, it's just a claim for an order from the court that says you can't do this. And what it involves is a detention center down in New Mexico that has a mandatory COVID-19 vaccination directive requiring all of the employees that work there or have contact with that detention center to be vaccinated. And a first responder did not want the vaccine, did not want to be vaccinated, and filed a lawsuit saying that you cannot have this mandatory COVID-19 vaccination directive. The relief this individual is seeking is that you can't terminate me or any other employees who refuse the vaccine. And again, what they're arguing is that there should be some limit on governmental power to mandate medical treatment for citizens, for private citizens. And so, again, in this case, it's not an ADA issue. It's not a Rehabilitation Act issue. It's more an issue with governmental overreach and the ability to dictate what type of medical treatment or medical procedures individual citizens have of their own accord. And so that's one to watch to see how that shakes out and see what the court does there. It's federal court, it's New Mexico, so it's not binding on us up here in Oregon, but it's not the Ninth Circuit. But it'll be interesting to see what the court does there because it might give us a look into at least what some courts in other areas of the country may do. The Ninth Circuit, of course, is the most employee-friendly appellate circuit out there. And so it's certainly, if this, does go the plaintiff's way, it's likely that we would follow suit out here as well, because the Ninth Circuit is not prone to, upholding employer-friendly laws and regulations. So keep an eye on that, and also keep in mind, that as you're deciding, do I want a mandatory vaccination policy or not? Should I just encourage it as opposed to requiring it? And we'll talk a little bit about incentive programs and things of that nature in a minute as well. But that's something to sort of keep in mind. Is there going to be pushback if I say you have to have it in order to come into the office? Are my employees going to respond to that? Are they not going to respond to that? And so that goes into the analysis that employers need to do when deciding what they want their return to work policies to look like. Number 6 here with respect to mandating vaccination is distinguishing between employees. As of right now, there really aren't any distances. The CDC has relaxed some of the recommendations with regards to what vaccinated employees can do with other vaccinated employees outside of the workplace. But inside the workplace, they're all essentially treated the same right now. It may get to the point where they're not. Once the vaccine is more widespread, they'll probably start relaxing some of these regulations and guidelines and rules. And in that instance, what you'll probably see is that you're able to then distinguish from them. But right now, there are absolutely no differences. Masks are required, whether you have a vaccine or not. Physical distancing must be maintained. The CDC has not said you have to be 6 feet away from non-vaccinated people. They say everyone has to be 6 feet apart. So these protective measures that are required due to CDC guidance, due to OSHA rules and regs, those apply across the board, whether the people are vaccinated or not. The one difference is that vaccinated employees don't require the same duration of quarantine as unvaccinated employees who may come in contact with somebody who has COVID-19 symptoms or a diagnosis of COVID-19. So they have a shorter quarantine period, if at all. But that is the main difference. Everything else has to stay the same. So even though your employees are vaccinated, don't soften the stance on masks in the workplace, on physical distance, and all those other safety protocols that are required by OSHA and due to CDC guidance, because you have to treat them all the same until the guidance and or the rules allow you to distinguish between them based on the status of vaccination. So keep that in mind as well, because as I mentioned, they have relaxed the rules a little bit, but they haven't done so with regard to the workplace. What they've said is that earlier this month, if you're fully vaccinated, which means 2 weeks after the second dose or 2 weeks after the single dose, if you get the Johnson & Johnson vaccine, that you can visit with other vaccinated individuals indoors and not wear masks or have to maintain 6 feet apart from them in their house. But they still say you should be restrict the number of people you come in contact with, right? Particularly if it's unvaccinated people from a single household, if they're low risk to develop serious symptoms of COVID-19. And then again, if there's no quarantine, if exposed to asymptomatic but infected person, unless they live in congregate housing. And that last part, that no quarantine, is the part that kind of bleeds into the workplace a little bit, because they won't be required to quarantine and miss that time away from work due to the exposure to an asymptomatic individual who tests positive for COVID-19 because they're vaccinated. Whereas if you had somebody who was unvaccinated, they would be subject to the quarantine requirements and rules that we have in place 10 days away from everybody else. So, we've seen the loosening of the restrictions started earlier this month. They're going to continue to get looser and looser, eventually getting to the point where, they won't require you to have masks amongst vaccinated individuals. But right now, you have to treat all of those individuals the same. You have to keep your safety protocols in place in the workplace. So no relaxing those. Keep it up. Everyone's doing a great job with those. We are seeing a handful of lawsuits around those. We are seeing some OSHA investigations around those, but you have to stick with it, because ultimately it can subject you to liability if you relax those, even though most of your employees have received the vaccine. So keep an eye out for the loosening restrictions and just any changing regulations and rules regarding COVID-19 in general as the vaccine becomes more widespread and case counts continue to decline across the state. I've gotten this question from employers out there. Can we have our own on-site vaccination party? Can we just go ahead and get some vaccines and have them brought into the workplace? At this point you could. I don't know where you're going to get these vaccines, but if you could track down some vaccines, according to the CDC guidance issued a couple weeks ago and the National Institute of Health, it is allowable. You could do some type of occupational health clinic, contract with them to come in and provide them. It's a good idea if you have a large number of workers with predictable schedules, so they'll all be in one place. If you're not a medical provider, definitely engage a provider. You don't want the janitor out there sticking people in the arm. So make sure that you engage a provider who can adequately do this, knows the safety protocols, unless you're some type of medical facility that is authorized to give vaccinations. You do need a big space, because you still, again, have to maintain the social distancing of all these people. You have to have them very spread out. You have to have enough space to monitor them for 15 minutes after they got the shot for any adverse reactions. So it's not just sit in the chair, get to poke and then go on. You have to have this a space where they can all be 6 feet apart and be observed by a medical professional to make sure they don't go into anaphylactic shock or have some other adverse reaction to the vaccine they got. So you could ostensibly host your own on-site vaccination party if you can find a clinic that has a bunch of vaccines and will offer them to you. This would probably be more likely to happen in those places that are higher on the food chain, if you will, for vaccine approval. So the places where you see these large workplace outbreaks, those types of employers are more likely to be able to put these on than other places, because frankly, right now, some of these other places aren't eligible for the vaccine yet. And so it's an idea, it's there. Certainly look into it if it is something that strikes your fancy. But I would, plan to offer it on site during working hours. Don't, no charge to the employees, pay them for the time they're there. You don't want to do it on a Saturday and make everybody come in, because that's potentially considered work time. You might have to pay them, which then potentially gives them overtime. So do it during work hours. You'll have easy access to the employees. They'll already be there. Again, that's assuming you have enough space to do it and you've contracted with an appropriate provider to provide these vaccines to your employees. But it is something that's allowed under the CDC guidelines and the National Institute of Health regulations. So that's an option that's out there for you as well. The administration of the vaccine, as I mentioned earlier, is not a medical examination in and of itself, because, which is a good thing, because if it was, it would need to be job related and consistent with business necessity under the ADA. And so, you might have a hard time arguing that the vaccine, that having your employees be vaccinated is job related and consistent with your business necessity, because your argument is probably that you just don't want your employees missing time from work if they come down with COVID-19 or get exposed to COVID-19. And so that's not going to be really job related. That's just employee related at the end of the day. And as well, when you have a medical examination, your information must be treated as confidential medical records. And you should do that anyways with the vaccination records. Even though it's not a medical examination, it is technically a medical record. And so I would keep it protected as an employer. And again, particularly if you're hosting your own on-site clinic, you're potentially opening yourself up to the pre-screening vaccination questions that could be considered disability-related inquiries, because you're going to be asking about their medical history to see whether or not there's a likelihood of an adverse reaction by the individual if they receive the shot. And a disability-related inquiry has to be job-related and consistent with business necessity. So they do have a carve-out for you, though. It doesn't apply to an inquiry that's asked by an employer who offers a vaccine on a voluntary basis. So again, that would not be a required vaccine. If you have a mandatory vaccine policy, then your pre-screening vaccination questions would be disability-related inquiries and would have to be job-related and consistent with business necessity. But if it's just an offer, we have a on-site vaccination clinic for our employees. You're not required to get the vaccine. It's just available for you. Come on out on your break if you would like one. That would be a voluntary basis, and that would not then be a disability-related inquiry because you're not requiring the vaccine. Also, another out that you have is if the administering third party, such as a pharmacy or healthcare provider, asks that, basically somebody that doesn't have a contract with the employer, so you can't tie them back to the employer, then it's not a disability-related question either. And so if you have a mandatory vaccine policy, you're safer and better off having an administering third party provide those vaccines, whether it's a pharmacy or healthcare provider, as opposed to contracting with somebody to do them, yourself, and just send them out to get a vaccine. Don't care where they get it. It's their choice. That way the questions that are asked do not get linked back to you, and you don't have any disability related inquiry issues under the ADA. And so, that's definitely a consideration and something to keep in mind, because again, we don't want to run afoul of those types of issues. So what about some other COVID-19 vaccine considerations, right? We've talked about mandating vaccines. That's basically what we've been talking about. But what other issues might there be out there? What other things should we consider in deciding, do I want to mandate a vaccine policy? Do I want to have some other incentive? Do I want to have anything regarding control or suggestion to employees of getting this COVID-19 vaccine. You know, one thing to keep in mind is that the COVID-19 vaccines are approved by the FDA under the emergency use authorization protocols. This isn't a fully vetted vaccine that goes through all of the other steps. That takes years. It's a years long process, which is why it's been remarkable how we've gotten to where we've gotten so far with these vaccines. That being said, they're granted under emergency use authorization protocols. So when you go to get your vaccine, it's required by the FDA that the recipient is notified that they have the option to accept or refuse the vaccine. So if they have the option because it's an emergency use authorization and they decline to get the vaccine, what do you do with that as an employer? You know, how does that limit your ability, if it does, to require the vaccine? You know, we'll talk about it in a minute, but ultimately, you know, that could be a wrongful discharge claim. It could support that, and we haven't seen these yet, but that's because not a lot of people are mandating vaccines right now. But if you had a policy that mandated employees had to get a vaccine, the employee goes to get it, is told by the administrator of that vaccine that they are allowed to accept or refuse the vaccine because it's only granted under the emergency use authorization, and they decline it and they are terminated or otherwise disciplined for violation of the employer's mandatory vaccine policy, they may have a wrongful discharge claim in violation of public policy under the argument that you can't mandate or force me to waive my rights under the FDA's emergency use authorization protocols for this vaccine because it's not a fully approved vaccine. It's just a vaccine approved under the emergency use authorization. So keep that in mind because, again, these are unique times here. You know, the vaccine was created remarkably fast. It's remarkably effective, but it's still under an emergency use authorization. So until it is granted full authorization, you know, you have to be cautious about considering whether or not employees may have a public right to refuse the vaccine and what you're going to do in those situations if you have some type of mandatory vaccine policy in your workplace. As I just mentioned, it potentially opens the door to a wrongful discharge claim. And a wrongful discharge claim is a common law claim in Oregon. It's essentially you can't terminate somebody if there's a public policy that would be violated in doing so. Ultimately, it's sort of a catch-all claim. It is preempted by any statutory claim. So if there's a statute that prohibits that type of behavior, it's a statutory discrimination claim as opposed to a wrongful discharge. The wrongful discharge is sort of the catch-all. It doesn't neatly fit under any statute, but it's a violation of public policy because public policy supports certain rights to employment, and it creates generally this public policy exception to the at-will employment rule here in Oregon. So keep in mind that angle because it is out there. It's a potential liability for an employer because that theory could get a wrongful discharge claim for somebody who accepts the EUA right to refuse the vaccine based on the required disclosure to them that's required by the FDA. So even though there's might not be a statutory prohibition on requiring vaccinations of employees in the workplace, you still have this potential wrongful discharge argument hanging out there. And, you know, we haven't seen it litigated a lot yet. It's still early. There's a 2-year statute limitations on wrongful discharge claims. So these wouldn't have to be brought for a while because you can't really have a mandatory vaccine policy at this point because not everybody's eligible for the vaccine. So, you know, as everybody, eligibility opens up, eligibility is going to be open here pretty soon for everybody over the age of 18. And therefore, at that point, when you're thinking about, do I mandate vaccination or not, keep this wrongful discharge issue in the back of your mind. Because even though it's not against the law to mandate a vaccine, you might be opening yourself up to a common law tort claim by doing so. Another thing to keep in mind is the workers' compensation impact or overlap here with COVID-19 vaccines. If you have an employee who has a negative reaction to the COVID-19 vaccine and you mandated that they get the vaccine, it could be a compensable injury, workplace injury, resulting in a workers' comp claim. They're only getting the vaccine because you required it. Therefore, it's a requirement of work. It's a work injury. So be cautious about that. And then, consider that workers' comp issue when deciding whether to offer vaccination through third parties that aren't within your employer's control. Because again, if they're outside of your control, as long as they're not contracted directly with you, if they go to someone else, you don't have as much control over it. So keep in mind that if it's a mandatory vaccination policy, it could be a work-related injury. If it's a suggested or that type of thing, but not required, there's less nexus there to try to shoehorn a workers' comp claim into there. So that's another implication that you have to keep in mind for mandatory vaccination policies is the workers' comp angle for an employee who has a negative reaction to a vaccine. Similarly, you've got leave issues they might have some time loss if they have to miss a day or two due to a bad reaction. I know that the reports out there, some people are totally unfazed by the second shot. Some people are laid up for a couple days. So again, if that's related to a mandatory vaccine, it's arguably a workers' comp claim, could result in some time loss for the day or two they miss from work for the recovery from that second shot of the vaccine. Another issue to keep in mind is the union. If you have a unionized workplace, your vaccine policy is typically going to be a subject of mandatory bargaining under the NLRA. You can't just implement a mandatory vaccine policy. You're going to have to bargain with the union for that. So you're going to have to check your collective bargaining agreement to see whether you've got a management's rights clause or a zipper provision in there, to see how you can go about getting this policy in there and what you're going to have to bargain with the union about. And also, even if you don't have a unionized workplace, keep an ear out, I guess, for protected concerted activity, because under the NLRA, employees have a right to engage in protected concerted activity under Section 7 of the NLRA, and that applies to both unionized workplaces and non-union workplaces. So just because you don't have a union doesn't mean they can't gain some sort of protected concerted activity protection under the NLRA, and you could find yourself fighting an unfair labor practice charge in front of the NLRB, even though you don't have a union in your workplace. So what you'd be looking for there would be employees who are collectively discussing, because again, it's concerted. Concerted activity means two or more employees. So if an employee is talking to another employee about it, then that would be concerted activity. And protected would be job related, because here you have a company policy that's requiring them to do something or not do something. And so if you have employees who are objecting to or protesting some type of mandatory vaccination policy, you have to tread lightly. You don't want to discipline them for that objection or protest, because that's protected concerted activity. So you got to tread lightly in those types of scenarios because they do have that jurisdictional hook under the NLRA to potentially get you in front of the National Labor Relations Board on an unfair labor practice charge. So unionized workplaces have their own special considerations. And hopefully if you have a unionized workplace, you're used to going through those channels and bargaining for the policies you want to see implemented. But just be mindful of that there's an extra wrinkle if you have a union in your workplace with regard to instituting some type of vaccination policy in the workplace. There also are wage and hour considerations to keep in mind. Do you have to pay employees for the time it takes to get vaccinated? And ultimately that just depends. If it's a mandatory vaccination, so again, if you're requiring your employees to be vaccinated and they do it on site because you provided a clinic for them, or you require them to go off site and it's during a time when they would otherwise be working, it's considered hours worked. So even though they're away from the office in the middle of the workday, it's not a break. It's not time off. It's work time, and you should pay them accordingly. If they receive a vaccine offsite and outside working hours, it's not considered work time. It's a little bit like the travel rules. If an employee travels during the workday, that's compensable time. If they travel on Saturday and they don't work Saturdays, then that's not travel. That's not compensable time because it's not hours worked. It's not part of their workday. So be mindful of that in terms of paying for these employees. Employees are, if you're going to mandate it, I say, you should probably pay them for that time anyways. Consider even paying it for them if you want them to go outside of working hours. Consider offering to pay for that time, because that's going to incentivize them to go, as opposed to requiring them to give up their weekend to try to go get the vaccine somewhere. I will note that there is a pending Oregon OSHA requirement that would ultimately force employers to cover the cost of vaccination, including travel. It hasn't been approved yet. It's Oregon, so it's probably going to get approved. So just be mindful that you may be required to cover the cost of vaccination, even absent this sort of FLSA wage and hour analysis. So be mindful that that's coming down the pike there, that ultimately you may be forced to pay for the travel and cost of vaccination. But at this point, if it's during the workday and it's considered, during the normal course of working hours, it's work time, it needs to be paid as such. And if it's outside of working hours, again, consider whether it makes sense to offer pay for that. Is that going to incentivize or ensure these people go get the vaccine if you're going to have some sort of mandatory vaccination policy? What about incentives? I referenced those earlier. What if instead of having a mandatory vaccination policy, I had some sort of incentive program where I encouraged people to get the vaccine but didn't mandate it? What would that sort of thing look like? You put some limits on the type of incentive. You obviously don't want to make it so large that you potentially get into a pay equity issue where you've got separate pay bands now between the vaccinated and unvaccinated people in the same job classification. So you should have some type of limit on what the incentive looks like. I know that there are employers out there who are doing $100 if you end up getting the vaccine. I don't know whether employees think $100 is worth it or not if they're opposed to the vaccine, but you'd sit down and come up with what the carrot on the stick is going to be for your workplace. But keep in mind that incentive programs could potentially violate pay equity laws even as a one-time bonus, because again, the people that aren't getting it are going to be getting paid less than those that do, even if they have the exact same job duties, the same qualifications and all of that kind of thing. You have one person getting paid more than the other one, which could be an issue. You also have issues with regard to disability or religious opt-outs, right? We talked earlier about the accommodations for somebody whose disability prevents them from getting a vaccine, or somebody who's objects to the vaccine on religious grounds, on valid religious grounds. In those instances, you're discriminating against them based on disability or religion. If you're telling me I'll pay you $100 to get a vaccine, they say I can't, I'm disabled, and you say, well, then you don't get the $100. You've treated them differently because of their religion or their disability. And so, you have to be mindful of that. I know some employers who have said, we'll pay you $100 if you get the vaccine. If you can't get the vaccine due to some disability or religion, then you take a safety course and complete that safety course, then we'll give you the $100 as well. And so it gives an opportunity for those individuals to earn that money and not be disadvantaged, even though they don't have the vaccine. So, that's one wrinkle. Boley says, that you can do these incentive programs, take it with a grain of salt. Again, if it's something that could end up violating pay equity laws, they recommend doing something along the lines of, if a certain percentage of the workforce gets it. I'm not a fan of that, because I think what you'll ultimately do is end up just passing the pressure on the employees down to the other employees. You're essentially incentivizing the other employees to harass their coworkers to try to go get the vaccine until 75% of the workforce has it, so they can get everyone can get their bonus. So, consider whether you want to do one. If you want to do an incentive program, I'd highly recommend, talking to your favorite employment law attorney to figure out, how do I not run afoul of, pay equity laws, of, equal employment opportunity laws, by offering this incentive to try to up the percentage of employees who receive the vaccine. Keep in mind, with the wellness programs have protections under the Americans with Disabilities Act, HIPAA, the Genetic Information Non-Disclosure Act, all of those types of things, regulate sort of your workplace wellness programs. And the EEOC has proposed guidance on wellness programs that offer no more than de minimis incentives. So again, we want to have some type of limit on the incentive. We're not going to pay, $1,000 everybody who goes and gets this. So it has to be some sort of de minimis incentive as part of the wellness program, in order to have some type of incentive to receive the vaccine. And so, consider that as an option. Again, we've got, do I want a mandatory vaccination policy? Do I want to do an incentive program? Do I want to just recommend it? You have options as an employer as far as how you deal with COVID-19 vaccination efforts amongst the workforce. You also have some employee relations concerns or things to consider, right? How are the employees going to take a mandatory vaccination policy, right? If I require that, am I going to get a lot of pushback? Is it going to be an unhappy workplace? Is everyone going to be surly and upset that we require this? Probably depends on the makeup of your workforce. It could have a negative effect on morale if you're requiring it and you have a subsection or a subset of employees that are actively opposed to it. You could have a little bit of an issue there. You also potentially have, administrative burdens of tracking who's got it and who doesn't have it. You're going to have to get sort of your vaccination cards, your vaccination certificates of everybody and track them down once they get their second shot, which takes weeks after they started the process. And so, there is some administrative cost associated with tracking that compliance. So you have to weigh that factor as well. The EEOC advises, don't mandate it, just encourage it, and again, is that through an incentive program or is that some other way of encouraging vaccinations? But ultimately, it's those are considerations as you sit there and think, what do we want to do policy wise with respect to vaccinations in the workplace? So that kind of wraps up the vaccination issue, the vaccination questions as far as policy goes. So what about other issues, other COVID-19 type issues in the workplace? One of the things is accommodation issues. And this isn't just necessarily related to the vaccine. This has sort of been ongoing, and we're seeing more of these kind of things sort of percolate or bubble to the top a little bit. But, as far as masks go, masks are required in the workplace. OSHA requires them, CDC, everybody says you got to wear masks in the workplace. Oregon's got its own requirements, state requirements as well from the governor's directives. And so masks are required. What if you have somebody that's hard of hearing? What if you have somebody that reads lips? You can't really do that with a mask on, makes it hard. And so, there may need some type of ADA accommodation or Rehabilitation Act accommodation for that, because if you have a thick, mask, an opaque mask, black mask or anything that's just not see-through, it impairs lip reading. And on top of that, it's a muffled sound. Everyone here has probably heard somebody talk through a mask, and it's hard to understand what they're saying sometimes. So ultimately, you may have to come up with some type of accommodation. Do we have an ability to have clear masks to where this individual can see the lips of the person that's talking to them and is still able to read the lips? There also, what about, having writing tablets, some type of a whiteboard with a dry erase marker or something like that, where the individual can write on them so that the person can read it, as opposed to, reading the lips instead. Just read the board, and ultimately you'd want to make sure those are sanitized and regularly, just like everything else that you have, but that could be a potential accommodation as well. And so, keep those in mind. There is a case, I've got it right here, that, next month there's a motion to approve settlement involving accommodations for somebody who is hard of hearing, that needed an accommodation for the mandatory mask policy. And again, this isn't necessarily an employer policy. It's a policy mandated by the government, not by the employer, just deciding to make policy. But nonetheless, you still are obligated to provide some type of accommodation under either the ADA or the Rehabilitation Act for an employee who has some type of a hearing issue, some type of hearing disability. So, there are still issues that we're dealing with regard to accommodations in the workplace that are related to COVID-19, even if they're not caused directly by COVID-19, if that makes sense. Other masking issues that we're seeing kind of pop up from time to time is what about when my employee uses their mask for some type of messaging, right? And whether it's sort of a Trump mask, a MAGA mask, or a BLM mask, or you're an employee has a Confederate flag mask, or whatever it is. Be cautious about how you regulate the messaging on masks, and that kind of thing. So, the EEOC has accepted charges where, an employer had policies regulating offensive, messages on T-shirts and such. So you have to be cautious about that. If you're a public institution, you've got free speech issues that are kind of, impeding and working their way into the decision-making process. But if you're a private employer, you have to be cognizant of that. And again, it's, probably going broader in terms of not attacking the substance of the message, but just, perhaps restricting messaging, because the messaging could mean one thing to one party and something else entirely to another. You also have to pay attention again. I mentioned the protected concerted activity earlier, but, be mindful of the concerted activity angle that might come through the masks. If you had a handful of employees who all went out and got no vaccine face masks or something like that, and you had a mandatory vaccination policy, you could arguably be touching on some protected concerted activity amongst those employees who seemingly all got the same mask and have been, acting in a concert with each other to try to spread that message in the workplace. So be mindful of that too when we come to, communications via mask. It's becoming the new buttons, right? You had, unionized, anyone with a unionized workplace knows what, when you hear about buttons, you hear about all those buttons that everyone has, the union buttons and that kind of stuff. And the masks are sort of the new buttons of the workplace in terms of being able to communicate a message, through something when you're required to otherwise wear a uniform or other type of dress that maybe doesn't have the ability to have some writing on it. So, masking has given the platform for some of these issues to arise in sort of a new medium. Let's talk a little bit about safety issues, workplace safety. How is that? Obviously, we changed a lot of things March of 2020 in what we were doing once the mandatory lockdown came, and then when we started coming back into the workplace, there were some serious restrictions on what we could and couldn't do with those. And OSHA, Oregon OSHA, has been sort of at the forefront of trying to mandate what the requirements are and what this looks like to maintain a safe working environment throughout the pandemic. So as sort of a refresher of what these temporary rules look like that were initially issued, is that employers are required to maintain physical distancing between employees, 6 feet or more of distance between employees in the office. Employees are required to wear masks, face coverings, or face shields when interacting with other employees. There's a COVID-19 infection notification process and inspector that needs to be chosen, some sort of safety communicator, if you will. It has to be designated by the employer. You have to provide for the removal of employees from the workplace who have symptoms or have tested positive for COVID-19. What do those protocols look like? You have to have workplace cleaning requirements with respect to maintaining a working environment that is decontaminated. So all the high touch surfaces and shared equipment and stuff needs to be regularly and routinely wiped down with disinfectant and all that good stuff that everyone's doing. And then there's a required poster that had to be posted in the workplace as well. And there were deadlines that were set for these things. Employers had to complete their COVID-19 exposure risk assessment last December, as well as develop an infection control plan. There were new ventilation requirements that were put in place by OSHA that had to be met by January of this year. And then there's required employee information and training that will become effective this year as well. So be mindful of those, because we now have permanent rules. These are the temporary rules we've been living under for quite some time. To be honest, we were all kind of doing this stuff before the temporary rules were even established last fall. People have been doing this stuff since the spring, but it became enforceable, if you will, by OSHA, and OSHA started coming into the workplaces to investigate and ding employers who weren't compliant with these requirements. But those temporary rules expire May 4th of this year. And so there are proposed permanent rules in place that would, take up after the temporary rules expire. And what that would do is it would maintain the requirements from the temporary rule, but also add some additional measures into the rules and make them permanent. Some of those added measures would limit transporting multiple people in a single vehicle, which can be rough on employers that have construction type businesses where employees regularly commute together and stuff like that. Everyone meets at the office, piles in the work van, and they all go somewhere. Instead, there's going to be restrictions on that, and you might have to require your employees to drive their own vehicles to the work site instead of carpooling in the company van. And employers with 10 or more employees have to certify in writing that they're running, their ventilation systems in line with the current ventilation requirements. You have to provide written notice of employees' right to return to work following a quarantine if the employee must quarantine for some reason. Again, there'll be presumably less and less need to quarantine as more and more people get the vaccine, but it eventually would top out if we didn't hit a high enough number to get that herd immunity. And so you still might have some quarantine issues from time to time with unvaccinated employees, or maybe a vaccinated employee who had a few symptoms of something and wanted to be away from the workplace. They don't infect unvaccinated coworkers. But ultimately, you'd have to have a policy, a written policy that provides this notice of what their rights are to come back to work after they've quarantined due to exposure to somebody with COVID-19. It also would require employers to cooperate with the public health authorities that ask to arrange for vaccination in the workplace. Again, not mandating vaccination, but require cooperation with public health authorities, which is frankly kind of required anyways. But it'll explicitly require that, and it'll require healthcare providers who, as employers, healthcare providers who are employers to provide to their employees respirators who, for those people who work with known or suspected COVID-19 positive patients. So, the nurses and those types of individuals who have to provide care and treatment to somebody who is suspected to have COVID-19 or who has symptoms of COVID-19. And it also strengthens the language discouraging the use of face shields, because obviously face shields are much less protective than face masks and face coverings because they don't really cover the mouth and nose, and they provide for the escape of germs around the bottom and around the sides of the face shield. So it strengthens the language discouraging the use of face shields, absent some documented or clear need for that if it's some type of medical accommodation or something like that. But basically, face shields can't be a choice. It's only an option if you cannot wear a mask for some reason related to a disability or something like that. So be mindful of these new rules. Again, they're proposed permanent rules. They're not yet in effect. The other rules are in effect till May 4th, so we probably won't see anything until sometime next month, maybe the end of the month, as far as when these rules go into effect and what they look like. But stay tuned. If you're a recipient of my firm's electronic alerts, we'll certainly send stuff out as these things come up, whether it's new rules that impact what you do in the workplace or extension of rules and that type of thing. We always stay on top of those. So if you've signed up for those, you'll be in the know once these rules are solidified in the future. Additional things regarding safety to be mindful of, particularly as employees come back to the workplace. Many places have had people who have been away from work for a year, and they'll eventually be coming back to the workplace. And what does that look like to them? What are the requirements? What are the concerns that you as an employer might have with all these people coming back who have stayed away from the workplace for a year? One of the things you should be, prepared to handle would be safety complaints. An employee who comes back and says, we shouldn't be doing this, we should be doing it this way, this isn't as safe as if we did it, X, and that kind of thing. And so, you need to do the legwork up front to make sure you've got policies and procedures in place to alleviate some of these concerns and show that you take safety seriously in the workplace, particularly regarding COVID-19, and that the safety of your employees is your number one concern. And you do that by maintaining copious documentation of everything. Policies, well-written, clearly crafted policies, laying out the requirements for employees to work safely with each other. I can tell you that our firm, we've got arrows on the ground because we walk clockwise around the building. We restrict the number of people that can be in a room at the same time, face masks required, all that kind of stuff. All that stuff, it's all laid out in a nice written policy. We've got signs everywhere, those types of things. The documentation of that is what's going to establish that we took this seriously and we've done our best to protect employees in the workplace. It's not a bad idea to have photos of employees utilizing these safety procedures and these precautions you've got in place. Every single lawsuit involving sort of, unsafe workplace involves somebody who was snapping some photos of somebody without a mask on talking to their coworker. They're going to say, here's what it looked like when you worked here. How nice would it be if you got sued and you came to me and you said, well, here's all the photos of everybody working safely. That was a one-off, that was a one-time thing, or frankly, that was even a setup by the individual. Who knows? But we can show that that's not regularly how it is. And so, that's not a bad thing to show. And you could even use it as sort of a training opportunity or an informational type thing. Photos of what you expect out of your employees. Here's what it looks like to be 6 feet apart from each other with your masks on, working together. Those types of things. And also the communications to the employees. Having the policies is great, but if there's no evidence that you ever told anybody what the policies were, it's not as great. And so the communications to the employees, hey, here's the new policy. If you have any questions about the policy, please talk to HR. If you have any suggestions, please talk to HR, all of that kind of stuff. The continued communications that, hey, listen, we take safety seriously. We take your safety seriously. Here's what we're doing. Reminders to people, if you see somebody who doesn't have a mask on, who doesn't do that stuff, you obviously talk to that individual, but you can also send out, company-wide emails. Reminder, we expect you to wear your masks, that kind of stuff. Again, it's the multiple touches, the multiple evidence that we don't just do this because it's required and we want to just have our piece of paper that we can file away and never look at, not enforce in case OSHA comes kicking in our door. So those types of documentation are very helpful in defeating these types of claims, be it administrative complaints or lawsuits. And you also have to be mindful of the fact that OSHA could come in and do an audit. If your employees are complaining to OSHA that you don't require masks, you don't require people to maintain 6 feet of distancing, and you're not taking all these safety protocols to heart, OSHA can come do an audit and inspect your workplace and potentially write you up for that. So, be mindful of that aspect and that angle too with the safety complaints in the workplace, because that gives them whistleblower protection as well, right? If somebody makes a safety complaint to management, they go to OSHA, they are a whistleblower, and so you have to make sure you manage your complaints properly. Understand that these employees may be protected whistleblowers, so you want to make sure you're not disciplining them or retaliating against them in some fashion for bringing these things up. Know that some employees are living in a state of panic. Some employees dread coming back to the workplace. That's just the nature of what we're living in right now. So be mindful of that, be courteous of that, have that in mind as you're trying to deal with some of these people if they're expressing some concerns or hesitations. Know that they might not be in the same frame of mind as you are because their level of concern is different for one reason or another. And if you get a complaint about something that your employee says we're required to do X, and you have no idea what they're talking about, look into it. It could be a new agency guideline somewhere they saw. It could be that they're totally misinformed and they're misinterpreting something, but it could be something that just came out. And, no matter how hard you try to stay on top of these things, you've got agencies all over the place, federal, state, local, that are all issuing these guidance and guidelines as things change. And, it could be a new agency guideline or something out there. Might only be a recommendation, might not be something you have to do, but don't just immediately dismiss it as that sounds ridiculous or that sounds crazy or you don't know what you're talking about. Because again, they might be a protected whistleblower and you don't want to open yourself up to a claim there. So as we look at bringing employees back to the workplace, we have to deal with the fact that some of these employees have been working from home for about a year now, maybe longer. And so you might have some work from home issues or, reintroduction to the workplace issues for your employees going forward. So can you require employees to return to the office? Yes, eventually you can. Depends on your local guidance and what the requirements are, statewide, depending on the level of your county and what's open and what's not open. But ultimately, yes, we'll get to the point where we can require employees to return to the office. We'll have to provide safe workspaces for them, whether they're vaccinated or not, because again, we can't relax the rules, the safe workplace rules, just because somebody's vaccinated until the federal agencies that regulate these or the state agencies that regulate these allow us to do so. Right now, we treat everybody the same: masks, 6 feet, all that kind of stuff. But be prepared for pushback from some employees. Some employees have gotten very accustomed to working from home. Some employees like not having the commute. Some employees have moved somewhere far away from work. I have a friend who moved out of state. His employer told him he could, but he moved out of state because he was told he can work from home for the rest of his life. So be prepared for some pushback from some employees. I think hybrid schedules are going to become more and more common, where you allow employees to work from home 1 or 2 days a week, but they're in the office the rest of the time. To me, the bigger question is, do you want to require them to return to the office? You have to kind of look at, what's best for your workforce and workplace. I saw a poll that I think nearly 75% of employees who were polled indicated a desire to continue working from home at least part-time. And so, if I do require this, is all of my talent going to look elsewhere for workplaces that offer more flexibility? If I require them to come into the office 5 days a week now, are they going to say, well, I like working from home part-time. I'm going to find somewhere that lets me work from home half-time and go to the office only part-time, only on occasion? Will productivity suffer though if you move to work from home and make it permanent, right? So you got to gauge how productive you've been in this pandemic year, which is tough to do, to be honest, because businesses have been affected, not just because of work from home, but for other, reasons as well. But has work from home allowed your employees to maintain productivity, or has it dipped significantly? If productivity is dipped, moving to permanent work from home is not going to increase that productivity or help solve that problem. So you got to look at that. If you have work from home, you're going to need smaller office space, because you won't have employees in there all the time. So is that savings on rent that you're paying, going to make it worth it, make it more enticing to you to allow employees to work from home? And what about other potential liabilities? And what I mean by that is, what if your employee is working out of state, right? Up here, we have a lot of people that live in Vancouver, right across the river from Portland. And, that's a totally different state. Am I in trouble if my employees start working from Washington? They're now Washington employees that work for an Oregon employer, but they work in Washington and do all their work up there. Down there, I guess if somebody commuted from California to your workplace, and they were working from home right now, they're a California employee right now. And so do you know where your employees are working? Also, you've got people, if they're working remotely, maybe they moved, maybe they're visiting family and they've been there for 6 months. Maybe they're thinking about moving somewhere out of state if they can work remotely, because they're not tethered or tied to the workplace anymore. So if they're working somewhere else, you have to be cautious about certain state laws. Payroll tax withholding can be dependent upon the location, the tax nexus of the work that's being done. And a business with a presence in other states typically has to register in that state. If you're just an Oregon business, you're probably just registered in Oregon. If some of your employees start working from California or Washington from their homes in those states, you might technically have a presence there. There's little guidance on what that means, but you have to think, do I now have to register my business in Washington as well? Or California or Idaho or whatever other state these people are working in. You might also have to provide workers' compensation coverage in the state in which they're working. So if they've moved somewhere else, or they naturally happen to live in a different state, you might need to provide workers' compensation coverage in that state, because if they get hurt working at home, they got hurt in that state doing work for you. And so, be cognizant of that. And if you're gonna go with a move to permanent work from home or partial, temporary, a hybrid type of work from home thing, Definitely have remote work policies in place. Put your policies in place that lay out what's required, what's expected, so that it's clear what this means to both sides, to both employer and employee. You can require your employees to work remotely in Oregon, right? If you're an Oregon employer, you can say you can work remotely, but you have to do it from this state. That's fine. You can do that. You can prohibit them from moving somewhere else or doing work from elsewhere. Be careful about it though, if they already happen to live somewhere else, right? If your office is in Portland and your employee works in Vancouver and they work from home and you say you got to come work in Oregon, you're essentially requiring them to either move, which they're probably not going to do, or drive across the border to do work from somewhere other than the office, in which case they might as well just drive into the office. So, be cautious about that. Be as sensible as you can, really, when you're coming up with regulations regarding that. But definitely keep in mind that you're probably going to get some pushback from employees who want to be remote, at least part-time, and also the concerns about where these people are doing their work if they are doing their work remotely. Here's a case in point right here, California Family Leave Act. If you have one employee in California, you got to have a policy for the California Family Leave Act. Again, if you have a remote worker in California, all of a sudden you better have this policy in place, right? You better be prepared to comply with this law. And so it's important to know where your employees are doing their work, to know what laws, if any, apply, if any of them happen to be working large periods of time from somewhere out of state. So let's move. I know I told you I'd leave about half an hour. We're coming up on 10 o'clock here. So I'll move through some of the non-COVID-19 things to know, and then we'll open it up to some questions here. But I said we talk about some policy issues and some upcoming laws to keep an eye on. So first and foremost, the big one, the big elephant in the room for employers and employer side employment attorneys is the Oregon Workplace Fairness Act. It was Senate Bill 726, came out last year, addresses issues surrounding workplace discrimination and harassment. It's essentially the Oregon version of sort of the Harvey Weinstein bill. What they don't want is somebody, particularly a powerful person like an employer, just paying hush money to their employees to prevent them from disclosing what's happening, so that the person can then go on, abusing, discriminating against, or retaliating against other individuals without anybody calling them out for it. So what it does is it extends the time for filing claims from 1 year, the prior statute of limitations, to 5 years. Employees now have 5 years to file a lawsuit following the adverse employment action. So 5 years after termination. It's a long time. Think about 5 years ago, how many people still work at your business. It's going to be a lot harder to try claims that happened 5 years after. It's hard enough already to depose somebody and have them try to remember what happened a year or two ago. Imagine trying to remember what happened 5 years ago in your workplace. So that's a big change. You also are required to tell employees in your handbook, in the policy, that they have 5 years to file claims. It also limits the use of non-disclosure, non-disparagement, and no right of rehire provisions in any type of severance agreement or settlement agreement with an employee or prospective employee. That went into effect October 1, 2020, last fall. So if you have stock severance agreements that you're using or anything like that, you need to have an attorney look at it and make sure it's still compliant with this. Because if you have any non-disclosure, non-disparagement, or no right of rehire provisions in that severance agreement, it's no longer, those provisions are no longer good, and you run the risk of having the entire agreement invalidated. You can use those if an employee requests they be included. So, you have to have an employee who says, I want a non-disclosure in there, maybe because they don't want the facts getting out or what happened at the end of their workplace, or a non-disparagement. Hey, let's agree to not say anything bad about each other so I can find another job down the road. But if they requested, it can be in there. Otherwise, you're not allowed to put them in there. So make sure you have a knowledgeable employment attorney look at that stuff. If you have any severance agreements or anything like that you regularly use, or when you want a severance agreement in the future to be used, make sure it's prepared by somebody who knows knows about these new requirements, because if it's somebody who just pulls up an old one they did in 2018, it's going to be outdated and potentially unenforceable. At least certain portions of it will be unenforceable. Also, October 1 requirement went into effect that you have a written policy for certain kinds of discrimination and sexual assault. If you don't have one and you're really worried that you missed the October 1 deadline and didn't get something in place, BOLI does have a model policy on the agency's website. It's written by BOLI, so take it with a grain of salt, but it's there. And what you need to do is make sure you have a policy in place that has all of the required language in there, and you have to make it available to employees within the workplace. You have to provide a copy to each employee at the time of hire, which will just put in your handbook, have the acknowledgement they signed and got it. And you have to designate somebody to receive complaints from employees and provide a copy of the policy to employees who disclose information regarding anything that might be prohibited discrimination or harassment at the time that the disclosure is made. So when somebody reports something that is discrimination or harassment, you need to provide them with a copy of the policy as well. So be mindful of this act. Here's some of the required policy provisions. You have to have a process for employees to report the prohibited conduct. Who do they report it to? What does it look like? You have to identify somebody who's responsible for receiving those reports. You also have to have an alternate person, right? If the person who's designated to receive the reports is the person the individual's complaining about, they need to have somebody else to go to instead. So HR plus somebody else. You have to include the statute of limitations, which I said is now 5 years in there. It has to state in the policy that you have 5 years in order to file a claim. You have to include a statement that you can't coerce or require a non-disclosure, non-disparagement agreement. You have to define what those mean to the employees. You have to include an explanation that an employee who claims to be aggrieved by discrimination under the law may voluntarily request to enter into one of those agreements that contain those things. But if that is the case, then the employee has 7 days to revoke the agreement. So if the employee says, I want those agreements, I want those provisions in there, you consent and you put them in there, the employee signs the agreement. 6 days later, the employee can say, never mind, buyer's remorse, I don't want to have this agreement anymore, and they can revoke it. And you don't have an agreement anymore. And you also need to include a statement that advises employees to document any incidents involving discrimination or sexual assault in the workplace. So, these are some of the things you have to have in this new sexual harassment discrimination policy for the Oregon Workplace Fairness Act. So make sure you've got a nice, robust policy. If you're using the BOLI one, that's okay. If you you don't have a policy, have somebody review it. If you made it yourself, or you haven't modified it since October of last year, now's a good time to pull it out and take a look at it, because this is at least one policy that needs to be reviewed and ensure compliance with it. It's also not a bad time to just review your handbook in general. Psychedelic mushrooms are now legal under supervision from certain treatments, so make sure your drug and alcohol policy definition includes things that you want to be illegal, even if they're otherwise allowable by law. So there are some things like that have changed, that it's not a bad idea to take a look at your handbook and have somebody review it if you have concerns about some of the things that have changed in the law over the past year. You also have some Department of Labor rules that are in flux. As Trump was leaving office, he ushered through some Department of Labor rules, some rulemaking, and as predicted and as par for the course, I guess I'll say, in the change of administration, the Biden administration came in and put a regulatory freeze on a lot of those rules. There is a prevailing wage rule that's going into effect that it brings prevailing wages paid to foreign workers in line with the wages paid to similarly employed U.S. workers, which essentially disincentivizes the need to hire foreign workers on a permanent or temporary basis over qualified U.S. workers, because now they'll be paid the same. You know, you were able to pay less to have these foreign workers come in. So now it's going to level those out to where there's try to incentivize the hiring of qualified U.S. workers as opposed to having you know, foreign workers come in on some type of a visa, like an H-1B or something like that. That's been delayed to May 14th. So it's still there. It's still going to go in effect. So keep that in mind if you have foreign workers with prevailing wage issues. There's also a rule that creates a selection process for H-1B visas, and that was delayed all the way through to next year. So the end of this year, you know, taking effect for next year. So, but the H-1B visas selection process is changing. But the regulatory freeze really, you know, took a cut out of some of those employer-friendly policies and rules that the DOL had pushed through it toward the end of the Trump administration. The independent contractor rule, you know, that tried to, you know, it made it easier to have an individual be considered an independent contractor. That one's probably not going to happen anymore. The joint employer rule also on the back burner, and basically is going to be done away with. And then the tip pooling rules that were going to go into effect also were withdrawn, the final tip pooling rule. And, you know, it remains to be seen what portions, if any of that, will be pushed through on in a different format. You know, the main issue, I believe, in that tip pooling one was allowing certain non-tipped activities to count toward the tip credit. And so that was, I think, the main reason, but ultimately they've pulled the whole thing. So that rule goes away. And so you know, we lose some of the employer-friendly DOL rulemaking that we got toward the end of last year. Other legislation to watch that's been introduced, you know, the Oregon ones were alluded to earlier. I'll go through a few of those that are out there just to scare you before we wrap up here. But the PRO Act, the Protecting the Right to Organize Act 2021, it aims to make changes to the NLRA. Basically, it revises the joint employer rule to essentially subject franchisors to liability for actions taken by their franchisees. You know, it's effectively the McDonald's rule, where they're trying to hold McDonald's Corporation accountable for McDonald's franchisees, you know, decision-making and behaviors of those employees. It passed the House this month, so we'll see where that one goes as far as franchisee joint employer liability. There's a very employee-friendly slate of Oregon proposed bills out there. I don't anticipate all of these will pass, but you know, it's something to keep an eye on. A couple Senate bills. One of them lowers the burden of proof for employees who assert discrimination claims, as if it wasn't easy enough to assert one of those in Oregon. Now they want to make it even easier. There's also one that creates a rebuttable presumption of retaliation, where an employee is terminated within 60 days of a report of a safety violation. There's going to be a presumption that it was retaliation, and then it'll be the employer that has to rebut that presumption. House bill that standardizes the test for independent contractor analysis, which is fine. There's numerous tests used in Oregon, depending on what agency you're in front of. So standardizing the test isn't a bad idea, but it also creates a rebuttable presumption that the worker is an employee and not a contractor when there's a question of fact regarding the proper classification. Again, sort of shifts the burden a little bit, which isn't very good. They're also, again, trying to chip away at non-competition agreements. House Bill 2325 wants to modify non-competition statute to make agreements simply void and unenforceable as opposed to voidable. Right now, the statute reads they're voidable and may not be enforced. You know, it's up to the court to determine whether they should void them. This one just makes them void as a matter of law if you don't comply with the requirements of the statute, and then seeks to reduce the effective period. And then House Bill 2205 is essentially your private Attorney General Act. California has a law that deals with this. And so, you know, Oregon decides that's pretty cool. We want one too. So it essentially allows individuals to bring public enforcement actions on behalf of the state. This is going to be costly to employers, as it'll just open up the floodgates to, some of these agencies and individuals going around suing employers as sort of their own private attorney generals, trying to collect civil penalties for violations. And then House Bill 2474 lowers the OFLA threshold for qualifying employers to 1 employee to basically subject everybody to OFLA, no matter how many employees you have going forward. So again, very anti-employer slate of bills we have there in Salem. And so again, we keep an eye on this stuff. If you're on our list, you get our electronic alerts. You'll know when some of these bills pass, because they're going to be big deals, and we're going to be advising you through those, how to deal with them and what you need to be putting on your radar. And hopefully some of these fizzle out. Hopefully all of them fizzle out, but at least the majority of them fizzle out and don't go anywhere. But at least it shows you sort of the mindset in Salem right now as far as employee versus employer favoritism. And so, keep an eye on these bills. It'll be interesting to see where they go. It'll also be interesting to see which ones get reintroduced if they don't pass, this session. That's it. We got 20 minutes or so to go over some questions. So I know Joe's going to be moderating this. My contact information is there on the screen. If you want to, write that down, shoot me an email, give me a call if you have any questions. If we don't get to your question, during this Q&A moderated by Joe.
Well, thanks so much, Sean. Wow. As usual, ton of great information for us to know about. There's a couple of quick questions I can get through real fast. The PowerPoint presentation, as in past employment law series, will be sent out by Sean if we have the participant registration list. And so Sean will get a hold of that, and he'll be sending his presentation out to all of the participants in the call today. Likewise, this presentation was recorded by the Medford Chamber, and Lydia will make that available to registrants again by email. She'll reach out to everybody and see who wants to get the recording as well. So those two things will happen. I'll try to get through a couple of these questions in the order they came in, Sean, so that you can address them. The first one is, are you able to require vaccines with employees age 16 and 17 years old?
I mean, not unless if it's, as long as it's a vaccine that's approved for them. Not all the vaccines are approved, I don't believe, for 16-year-olds. And one or two of them are. I don't know about all 3 of them that have been approved yet, and I don't know about the ones that are, out there, that the next in line. I know there's an AstraZeneca one, and there's a couple others that are out there. I know that they're currently testing for even younger than that, but ultimately, I'd tread lightly on that, just because A, they're less likely to be seriously impacted if they do come down with it. And B, I'm not a fan of the mandatory vaccine policies just in general. I think there's too many, potential potholes that you might step in there trying to enforce that. You might get some pushback, because if you try to, mandate that a 16-year-old get it, their parents have some say in their medical treatment and things of that nature, what they get. So you probably get some extra pushback in that regard too. And so you might have that wrongful discharge argument. There's no law that would prevent you from doing so, but you have that potential public policy issue that may subject you to a wrongful discharge if the employer refuses, and then you terminate them or otherwise discipline them in some way.
And I'm going to see that apply for all minor employees that might be employed by a business.
Yeah.
Gotcha. What is the quarantine time for exposure to a vaccinated employee? Do you have any information on that?
Exposure to a vaccinated employee who has symptom? I'm not sure what the question is. The exposure is, I believe the quarantine period is now down to 10 days for individuals. If they're vaccinated, they don't have to quarantine. Because they're going to be deemed to not do it. If you had a quarantined employee who nonetheless got it and tested positive, all of the non-vaccinated employees that had a close contact with that vaccinated employee would need to quarantine under the CDC guidelines. But the vaccinated employees would not. They've done away with some of the quarantine requirements for the vaccinated employees.
Gotcha. And so can you ask for proof of a vaccination from an employee?
Yes, if you require it, you can ask that. It's not a medical request. I probably wouldn't ask unless you have a mandatory vaccination policy, because there's no need to know if you're not requiring it for some reason. If there eventually becomes a need to know, such that, maybe the CDC guidelines say non-vaccinated people don't need to wear masks in the workplace, then you're going to need proof, because you're not just going to take, Jim's word for it that he got the vaccine and he's not going to wear a mask anymore. You're going to want to see that he did get the vaccine before you let him not wear a mask in the workplace. But right now, everyone, vaccine or no vaccine, is required to wear the masks. So there isn't really a need to know unless you have some sort of a mandatory vaccination policy.
Gotcha. And the question came in, is it possible to reach herd immunity at your place of business? In other words, like if 80% of the team or your staff has full immunization, is that considered relatively safe for everyone in the business?
That's more of a medical question, but I would say not necessarily, because they don't just live at the workplace. Who knows who they're coming into contact with outside of the workplace. And so, those unvaccinated employees you have, if you have 80% of your workforce vaccinated, you still have 20% unvaccinated, and they could still catch it somewhere other than the workplace. And so, and if they do, they can then transmit it to other unvaccinated workers in the workplace. And so obviously the more vaccinated employees you have, the less likely you're going to be to have some sort of an outbreak or passing it amongst employees. But it doesn't necessarily mean that you might not have somebody that still catches it elsewhere, brings it in, because if the community doesn't have herd immunity, these people could still catch it out of the restaurants, the bars, family get-togethers, whatever it is, and then bring it into the workplace and expose. The vaccinated people will be fine, but the unvaccinated coworkers may need to quarantine if you have an unvaccinated person that catches it in the community or something like that.
And so a question came in is, why does taking or not taking the COVID vaccine why does it not fall under HIPAA protection?
As far as, I'm not sure what that question
So the question is, why does taking or not taking the COVID vaccine not fall under HIPAA protection?
HIPAA just protects records from disclosure. So HIPAA protects medical providers from disclosing your records. The only thing that would potentially be HIPAA would be proof of the vaccination, because that's the only medical record you're really talking about. And most employers aren't medical providers that are technically bound by HIPAA. A lot of the medical stuff technically falls under the ADA, because HIPAA only protects medical providers who have records from disclosing those records. Employers are allowed to request medical records for FMLA stuff, right? And so I can get medical records of my employees in certain circumstances. It's not a HIPAA violation for an employee to say, I'm having surgery, I need to be out of work for 2 weeks, and you say, bring a note saying you're having surgery. That's not a HIPAA violation, even though it's a medical record from the doctor. Employers frequently get medical records with regards to workers' comp claims and stuff like that. So it's not really a HIPAA violation or a HIPAA issue as far as whether the vaccine is going to be required by employers or not. It's more of frankly, it's more of a public policy issue as far as, can somebody require me to get some type of vaccine? And again, it's not a requirement. You can just choose not to work here.
Got it. And so, back to the topic of requiring employees to come back in the office, what if we have an employee that has a note from their doctor that says that they need to stay at home indefinitely, even though we have safety and sanitary practices in place? How do we handle that?
So this is where it's going to get really interesting, right? Because the case law out there, which is not related to COVID, it's related to other things, says, leave of an indeterminate amount is not a reasonable accommodation. And so the argument will be that, we can't provide indefinite leave to you, and therefore we need to know when you're coming back. If you don't know, then we're just gonna have to, lay you off, and, you're eligible for rehire if you ever are able to come back into the office at some point. And you can go down that road. But, there's this argument of, well, I can just work from home. And it'd be hard for employers to argue you can't work from home if you've been doing it for a year. You're going to have to be able to articulate the reason you need this individual in the workplace, in the office. The teamwork aspect of whatever they do, there are certain things that require collaboration that just can't be done over, telephone or Zoom or that kind of thing. And but the fact that we've been doing this for so long definitely undercuts the employer argument a bit, because that employee is going to go around and say, listen, I've been doing it for a year. I can do it. I can continue doing it. You aren't harmed by it. You let me do it for a year. And, we'll, of course, as employers say, it's only because we had to. It's not our preferred method. We suffered greatly while you worked from home for a year, and here's why, X, Y, and Z. So now we need you back in the office. But so at that point, I think, the answer was different, I think, towards the beginning of this, because nobody knew when the pandemic was going to end anyways. Now that we, kind of hopefully see the light at the end of the tunnel a little bit here, and we see that, we're going to be getting back to more normal. We're going to be allowed to all come back into the workplace. We're going to be allowed these other things. For employees that still want to stay out for an indefinite period of time, it becomes an accommodation issue. Is, do I have to grant this as a reasonable accommodation once I require everyone to come back into work? And you go through your sort of your ADA analysis, and is the request due to a disability that's covered by the ADA? And if so, we got to go through the interactive process and figure out, is there actually a timeline this person's coming back? Is it whenever COVID-19 goes away? Because it may never go away. It may become, like all these other seasonal flus and coronaviruses that kind of are out there every year. So what is the doctor actually, telling them as far as what they're recommending is for staying home? But it's an accommodation interactive process question that you have to run through, and ultimately indefinite leave is not a reasonable accommodation at the end of the day, but you do have to fight that uphill battle of, they're going to say they can do their job from home. You said they've been doing it from home for a year.
And you also had a slide in there about requiring, if you mandatory a vaccine, that you have to pay for an employee to go get that in terms of hours or time or whatever. This question is an employer required to provide extra PTO for an employee to get a COVID-19 test?
So the FFCRA provided paid leave for that. If it's a medical test that's required by the employer, you have to pay for the cost of the test, the cost of the visit, whether that's just whatever out-of-pocket expense the employee had. It has to be paid for by the employer if the employer requires the test. If the employer doesn't require a test, just says you have to go home for 14 days because you've got a cough, and they go get a test, that's on them. That's not a requirement of the employer, and they wouldn't have to pay for it. If you send somebody during the workday to go get a test, that's work time, and you need to pay for that. But there isn't any actual required leave at this point, unless it could fall within your regular PTO where you allow them to take leave. If they're exempt, you don't want to dock their pay necessarily. If they've done work during the week, you don't want to potentially destroy that salary exemption. So, you have to look at it sort of on a case-by-case basis, but it depends on what the impetus is for that test. If an employee just wants to go get a test, you don't have to pay for it. If you're requiring an employee to get a test, you have to pay for the cost of it. And then whether you pay for the time depends on when the test is taken, essentially.
Good deal. Also, there was just one quick point of information in your presentation. It talked about the employee information and training requirements. I think in one of your slides, it says it was required by 12/21/21, but isn't it that it's required by 12/21/20?
It's probably a typo. I don't have the slide in front of me, but it might be a typo.
No worries. I just wanted to point out that might have been a point of confusion to a couple of the viewers. You might, take a look at.
Sure.
And so that pretty much runs through the questions. Also, these new or OSHA regulations and rules after the 4th of May. I know we want, our participants to get on your Baron Liebman mailing, because that's going to be able to put out more direction on what they are and when they're coming out. So just wanted to make sure that we knew that everybody can get on your mailing list. Is it just simply to email you on this last slide and you'll put them on?
Yep, just send me a request. Just shoot me an email, SRAY@Baron, BARRAN.com, and just say, hey, please sign me up, and I'll pass it to the marketing team and make sure you get added onto that list, so that everyone going forward, you should be seeing hit your inbox.
Sounds good. Well, I don't see any other questions, so I'm going to do a quick wrap here. First and foremost, I want to, thank Lydia at the Medford Chamber for, orchestrating this webinar. She's done a fantastic job in getting communications out and working through all of us on the screen here and doing that. So thank you, Lydia. Obvious thanks to Brad, Heather, and Josie at the chambers. Our chambers are amazing organizations that are out there not only giving us information and providing all that, but they're also advocates for us up on the state level. So all those measures you saw in 2021 that are coming through the legislature, all of us on this call should be mindful to get back to the chamber with how you feel about this and allow our chambers to advocate for us. We're so thankful to the chambers for doing that. Sean, we're obviously incredibly thankful for you as well. I know that just that last slide of all these new actions that are coming down, that's fodder for the cannon. You'll be here next year. You'll be commenting on all those. We want to see all the participants on this call join us next year as well for the ELS that we'll put on. It usually is in this March, April timeframe, and the chambers will get this out through the chambers again. So again, on behalf of BBSI, on behalf of Baron Liebman and all the chambers, I want to thank everybody who got onto the call to participate today. If you have any questions or whatnot, email Sean, email myself, joe.rossi@bbsi.com. We'll be happy to answer anything and everything that comes our way. So thanks to everybody. Have a really great work week, and signing off.